Go, hey, go team. Courtroom 1. Yes. You go first. What's the position? Give me 1 second. 25.
All right, good afternoon, everyone. We'll get started. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is the calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. Mr. Jordan, what's the reset date for SAP?
October the 24th is the reset date.
Okay. 10/24 is the SAP date. I want to begin by reminding everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to remind the defendants that you do have certain constitutional rights. The first being that you have the right to counsel. You should know who your attorneys are at this juncture. Also, you have the right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrence of your case can and will be held against you. The state is here, they're listening, so follow the lead of your attorney. Who do we have first?
We'll go on position number 25.
Okay. That is it Deja Smith Johnson, 24 CR 00701OG, charged at 1 count of simple battery against a police officer, detention officer, and a 2nd count of criminal trespass. Pre-trial?
10 total. Got an open felony, 24 SC 002752. Cruelty in the first. PI. Cruelty in the second. On probation for trespass, battery DB. It's 18 CR 000040A. On probation out of state court for trespass, 19 CR 0010256A. Also on probation for disorderly conduct and obstruction. It's 24 CR 000938G. That's an FTA from this year, 2019 trespass conviction. 2018 trespass battery DB conviction. That's it.
All right, state.
Thank you, Your Honor. This is an incident that occurred on the 10th. This was at 6701 Shannon Parkway in Union City. Police, specifically Union City Police, were speaking with the defendant. It was revealed that she had a failure to appear warrant. When they went to go detain her, she resisted. She reached out and struck Lieutenant Francisco Sedano in the face. She made his glasses fall off of his face and they broke as a result. You did just hear that she's got an active failure to appear out of felony court for a pretty serious case. Her criminal history includes mostly assaults on individuals. We would ask for a BHET, a $2,000 surety, no drugs, alcohol, and weapons, Your Honor.
All right. This is Mr. McLean.
Yes, Your Honor, the BHET is appropriate, and we would ask the court to consider as low a bond as possible. I do note that I believe in the felony case that was referenced, I think a couple of counts were dismissed. Could be wrong on that, but I think they were. But the felony case survived as a felony nonetheless. The two counts in this are the same. Well, no, the criminal trespass, I suppose, is probably breaking the glasses. So never mind on that. So we would ask the court to just give her a fair bond.
All right, I'm gonna order the $2,000 surety bond. That's $1,000 on each of the charges. I'm gonna order, this Shannon Parkway address was just somewhere where she's found. Is there a stay away? I didn't hear one.
No, Your Honor.
Okay, no, further contact with, or no further violent contact with law enforcement unless she's, seeking assistance.
Thank you.
BHET, no drugs, alcohol, weapons, unprescribed medication, or guns while on bond. And, I think that'll be it.
Next is gonna be position number 23, Ms. Laura Norris.
Twenty-four CR 0070009F, Laura Norris, charged with one count of battery family violence.
Second arrest, 2009, breaking, entering, dismissed.
Your Honor, this is an incident that occurred on the 25th of September at 4910 Hampton Square Drive in Johns Creek. Police were called to that location, and there they spoke with the victim, who is the son of this young lady. His name is Alexander Norris. He reports that his mother, who does not live at the residence and suffers from MH as well as substance issues, had come to the location because her estranged husband, the father of the victim in this case, is suffering from some serious health issues. And she became upset and started screaming at people inside the location, specifically the father who is ill. The defendant became upset, went to go unplug the television, and when her son tried to stop her, she bit him. He was seen to have a raised bite mark on his arm. We've spoken with the family today, Your Honor. We'd be requesting social worker visit, BHET, $2,000 surety, no drugs, alcohol, or weapons, stay away from the location at 4910 Hampton Square Drive, and no contact with the family members there in the Norris family. And Mr. Alexander Norris is here on the Zoom. If you'd sound for him, please.
Okay, Mr. Norris.
This is him.
All right. Do you wish to address the court today? Yes or no?
Yes.
All right, raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Let me ask you this. Are you driving?
No, I'm just sitting in my car in a parking lot.
Oh, okay. Make sure you're not driving. Are you in fear of Miss Laura Norris? Can't hear you. Can you hear me? For some reason, your sound went out. Can't hear you. May have lost it. Did he fall off? Oh, there you go.
Sorry
All
about
right.
that.
Are you in fear of Miss Laura Norris?
Yes.
Okay, do you want to have any further contact with her right now?
As much as I love my mom, no.
Okay, I understand it's difficult. All right, any cross-examination from the state?
No, Your Honor.
All right. Mr. McLean?
None, Your Honor. Thank you.
All right. I appreciate your time, Mr. Norris. You can mute yourself and listen in to hear the ruling of the court, okay?
Thank you, ma'am.
All right, thank you. All right, Mr. McLean?
Your Honor, I wonder, is Dina on the line, her sister in Raleigh, North Carolina? Is she on Zoom?
If she is, it
Yes,
doesn't.
yes, Mr. McLean, I'm right here.
All right,
Okay.
I don't know that I need to hear from her unless we're going to break out on the MH, but I think I have a sense of what's going on. Plus, she's
There,
not even here in Georgia, is she?
no, she's in Raleigh, North Carolina. I have a proposal that I just wanted to make sure that the family, as much family as possible, was in on things. Your Honor, I would propose a signature bond. I spoke on the phone earlier with the sister in North Carolina who said that there is I believe, a hotel room or some room that is available for at least one night, if not more nights, even here in Atlanta. The defendant would like to go back to, my client would like to go back to North Carolina, but that may not be feasible at the moment. But in the meantime, I believe some of her family believes that she could make it here in Atlanta and keep up with things and has a place to stay right here in Atlanta. She doesn't
Mr.
have.
McLean, I am ready to leave to come to Atlanta.
Hold
to
on,
get her.
hold on. I haven't sworn you in. I haven't allowed you to speak, so please don't interrupt. Let me hear what this plan is. Okay.
Thank you. Yes, sir. Ma'am.
So I'm simply proposing that it be a signature bond. All the other elements, all the other conditions we would agree with. The social worker visit, the BHGT.
How do we know she's getting back to court? Or coming
Well,
back to
she's
Georgia for court?
well, I'm not sure she's even going to succeed in going to North Carolina. I heard, she wants to go to North Carolina. The sister says not yet. She's got a place to stay in Atlanta, and I don't think she's so disorganized that she can't keep up with court. So if she indeed does have a place to stay in Atlanta, then I would propose that she just have the signature bond and make her court date.
How old is she?
Let's see. Is it 62? 66?
Yes.
Okay.
Working, retired? What?
She's been a homemaker for 42 years.
You have a bad connection, Mr. McLean is going in and out on me.
She's been a homemaker for the last 42 years, Your Honor.
And she has somewhere else to, well, she doesn't live with the victims anyway, so she has somewhere else to live, correct?
Correct. I don't know where, but yeah, I believe that's correct.
All right, I'll give her a signature bond through pretrial, but I'm a little reluctant on it. I want to make sure she's going to get some help or assistance for what she needs in order to be stable. So I'm going to make it a $3,500 signature bond through pretrial. And I'm going to have her to take 2-day anger awareness course through pretrial. I'm going to order her to stay away from 4910 Hampton Square, was it? What was the
Yes.
address? State Hampton Square Drive, maybe?
Yes, Your Honor.
Then Johns Creek, stay away from there, have no further contact with the Alexander Norris, or there's another Norris at that house.
John.
All right. No further contact with them right now. I'm going to order BHET and to comply with any medications or treatment that's recommended. No drugs, no alcohol, no weapons, no guns, no unprescribed medication while on bond. And remember, Ms. Norris, you got to stay 200 yards away from John and Alexander. That's 2 football fields. They see you coming, call police and you'll be back in jail. You're not to have any contact with them whatsoever by phone, by email, by text, or nothing at all right now. We want to make sure there's going to be an ample cooling down period, hopefully, and that, oh, and I'm also supposed to order BHET. Did I say that?
Yes.
Okay. So to see if there's any other assistance they can give. That's the order of the court.
Hey, what's that level, Judge?
Level 2,
Level 2? And let me get that bond amount again, please.
3,500.
35. All right, thank you.
All right.
Thank you, Judge.
May I speak? I guess not.
No, I'm sorry. Miss, is it?
Dina?
Ogani?
Yeah, just
Yeah.
call me Dina.
Oh, no, I would not call you by your first name. I would try to pronounce your last name.
Thank you. Belgodere. Yes,
Okay.
ma'am.
Usually I don't hear a lot at this stage from the family. This is just a bond hearing. This is not her trial. And I've
Yes, ma'am.
ordered certain conditions that you can discuss with her attorney, Mr. McLean,
Understood.
and he will give you a call to
Mhm.
explain that.
Yeah.
But as much assistance as you can give her, fine.
She has my full support.
I'm sorry.
She has my full support. I am going to abide by everything you just said, and I will kick her in the butt if she doesn't apply.
I love it. Thank you. We need more people like you. Okay.
I
But
love my
yes,
sister. I'll take it.
good. All right. Well, take care of her and wish you all the best. Okay.
God bless. Thank you again,
All right.
Your Honor.
Thank you. All right. Bye-bye.
Next, Your Honor, is going to be position number 17, Mr.
Okay.
Quentin Horn. He has primary counsel.
You off. Where are you?
This is 24 CR 0069990J.
Leave. Thank you. Leave me.
Quentin Horn. I'm in charge of one count of simple battery. Mr. Jordan, can you help to kick them off the Zoom a little bit to help them to get out? Thank you. All right. Go ahead, pretrial.
2022 ag stalking, hindering 911 call battery. That was out of Clarkston. 2022 battery DV, simple battery conviction. 2015 possession of a firearm by a convicted felon, sale of marijuana conviction. 2010 simple battery DV, obstruction, NOLO. That's it.
All right, state.
Thank you, Your Honor. This is an incident based on a private action. There was a police report in this situation, but no arrest. The victim in this case, Yesha, Yeshia, first name, last name is Royal, went through the magistrate court process and obtained a private warrant following this incident. This is from March the 20th of 2024 at 191 Cleveland Avenue Southwest. It's a child care center. It's reported, and I've reviewed the police report as well. There were witnesses present. The defendant accompanied a young woman, last name Abrams, and her mother to a parent-teacher conference at the daycare location where this happened. They were discussing a child, and the parents, the three people present, the defendant in front of you, the young woman he was with, and her mother became hostile and had to be asked to leave the facility. They were yelling and screaming. At one point, witnesses reported that the woman Mr. Horn was with put her finger to the forehead of one of the ladies at the daycare and pushed her. And at a certain point, the defendant here grabbed the arm of another woman, and that's Miss Royal. She went through the magistrate court process, and in a hearing on August the 23rd, 2024, a warrant was signed by Magistrate Court Judge Bobby Wolf. The defendant fled the vehicle after this incident in March, and multiple people were spoken to on the scene. We spoke to the victim. She reported that she was and is a worker at the daycare. It's the Schoolhouse Academy. She'd had a conversation and a conference with the child's mother and was terminating services with them when the defendant came into the daycare aggressively and was aggressive with her and staff. He was asked to leave. He told them he wasn't going to go anywhere. She explained that she was going to call the police, and that's when he grabbed her arm, and she thought it was to prevent her from calling police. She also reported that he was armed, although I didn't see that in the application process. You did just hear that he's got a criminal history that includes not just felony convictions, but convictions for violence and convictions for firearms, which he should not be in possession of. We'd asked for a stay away order from the location, which is the daycare. He's got no reason to go back there, but also a $2,000 surety based on his criminal history and no drugs, alcohol, or weapons while on bond. Thank you.
All right, Mr. McLean.
Actually, Your Honor, Nicole Fagan on behalf of
Oh.
Mr. Horn.
I'm sorry. Thank you, Ms. Fagan.
Thank you, Your Honor. Your Honor, we adamantly dispute the allegations involved in the police report. We strongly believe that my client was actually trying to mitigate the argument between the women and trying to separate them and get them off property and move forward. He is on active probation and he is in complete compliance. We have good communication with the probation officer, so I'm not sure how this slipped through the cracks since March because my client would have turned himself in without an issue. We are requesting a $1,000 bond. We have no issues with any other conditions that the state recommended.
Okay, thank you. All right, I'm going to order the $2,000 surety bond. I'm going to order stay away from 191 Cleveland Avenue. I'm going to order no further contact with the employee Yashia Royal. I'm going to order no drugs, alcohol, weapons, or guns and unprescribed medication while on bond. And I think that's all I'll order for now.
Thank you.
Thank you.
Thank you, Your Honor.
All right, thank you.
Next, y'all, is gonna be position number 22, Mr. Tremaine Newsome. He also has private counsel.
Okay. This is 24 CR 006-987J. Tremaine Newsome, charged with 1 count of battery. Pre-trial.
5 total, 2022. Possession of a firearm after family assault and battery. That's one of them out of state. Reckless handling of a firearm, brandishing conviction. 2021 assault DV abduction conviction. That's it.
Okay.
So, Your Honor, this is a dual arrest case. The co-defendant's name is Reginald Freeman. He's also on the docket today.
Freeman.
He is position 13.
Okay.
The criminal history you just heard about is from North Carolina and Virginia. The defendant in front of you, Mr. Newsome, has no criminal history out of Georgia up until now, although he does have a family violence conviction and he is prohibited from possessing a firearm. That was in 2022. Police were called to 396 Piedmont Avenue Northeast on the 9th of October. It was reported that the maintenance man in charge of garbage at the location was in a physical dispute with the security guard. The security guard is the man in front of you, Mr. Newsome. Maintenance garbage is Mr. Reginald Freeman in position 13. Both of the individuals were seen to have injuries on their face. This was about at 11 a.m. Mr. Freeman reported that he was doing his job when he was told by the security guard that he couldn't have specific access to an area where he was. They exchanged words, challenging words. It's described that as they were going into the elevator. They started to verbally argue. Both individuals chose to be in the elevator together as this escalated. The security guard, Mr. Newsome, in front of you, claimed that the defendant, Mr. Freeman, got in his face, nose to nose. And so Mr. Newsome says he pushed Mr. Freeman. That would make him the initial aggressor. And that at that point, they started to throw punches. Mr. Freeman reports that he went to go push a button in the elevator as they were arguing. And at that point, Mr. Newsome started throwing punches. So Mr. Freeman was seen to have swelling to the right side of his face as a result of being struck by Mr. Newsome. And Mr. Newsome was seen to have swelling and soreness or bruising to his right hand as a result of being injured in this altercation. The criminal history is concerning. I'm not sure how you can be a security officer. You can't have a gun and you've got prior assault convictions for domestic violence and possessing firearms. But nonetheless, the state would be asking for a $2,000 surety bond, Your Honor, to surrender all firearms and no drugs, alcohol, or weapons, and to have no contact with Mr. Freeman and stay away from the location there at 396 Piedmont Avenue Northeast. And we'd be asking for the same bond for Mr. Freeman.
All right, counsel, is it Strobel?
Yes, ma'am. Dustin Strobel for the defense. As stated, Mr. Newsom is employed by Advanced Protective Services. His boss is actually in the audience today. He still supports him. They actually conducted a thorough investigation of this that they're still ongoing after they learned of his arrest. They have contacted the witness that was initially made the report, a Mr. Lee Jones, who reported that he witnessed the altercation and that after it went on that it was the co-defendant that was yelling epitaphs of various types, mostly against a sexual orientation, stuff that, and actually made a comment towards Mr. Newsom that I am going to get your blank, 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 blank arrested by any means necessary. You're going to learn today. They were also able to turn up a video into the parking garage, which is where the altercation ended, that showed the co-defendant after being escorted off of the premise or being removed from the premises, turning around and running back into the thing where the altercation, the primary part that was reported, occurred. Reports indicate that he was trying to access a pool, which was off limits and that he knew of. That was at around 10 p.m. That was when Mr. Newsom, being the security guard on scene, escorted him off the premises to ensure he was there. We have also had contact with Crystal Baronitos, who is the community manager for Skyline Apartments, which is where this occurred. She is not seeking that Mr. Newsom be prohibited from the apartment. In fact, like I said, there's no complaint. She contacted the trash valet service, and honestly, they informed him that they had plenty of issues with the attitude and stuff of the co-defendant, Your Honor. So we're definitely asking that he be allowed to remain on the job and work there if his employer, Mr. Timothy Farrow with Advanced Protective Services, still feels that location is appropriate. Your Honor, I was not aware of his criminal history. Normally, I would ask for a signature bond in situations like this, since it does not appear that he was the primary aggressor. Any force he used, I would argue, would have been necessary for the removal of him as a part of his job. But I do think definitely allowing him back on the services, no contact with the co-defendant is not a problem. I would ask the court for a low bond of around $1,000. I think that is appropriate in this case.
Okay. Well, he does have some concerning history, although it's 5, but they are interesting. I think the state mentioned the surprise he's a security guard with that kind of history. I think 2022.
And Your Honor, I believe Mr. Timothy Farrow is there if you would like to ask him about his character and stuff.
I won't dive into why he's a security guard, because that's not my issue here today. Is just to make sure that he will return to court, and he's obviously has enough contacts and ties. How old is he?
Mr. Newsom, how old are you?
25.
25?
Yes, that's
All right, he's very young. But these firearms, these assaults and things of that nature are the things that I look at. And I'm assuming he's from out of state. I don't know. North Carolina,
Newsom,
Virginia.
Yeah, he lives here, Mr. Newsom. How long have you lived here?
I stay here a year now. I've been here
A year in Georgia.
And he is gainfully employed with the employer that keeps track of him.
Okay. Well, I'm going to just want to make sure that this is over. This was October the 9th. Today's the 11th, and that there's been the ample cooling down. Glad he can keep his job. I will give him a $1,000 surety bond. And with that surety bond to have no further contact with Mr. Freeman. Now, I guess my question to that would be, are they both still going to be working there?
My understanding from what the community manager reported back to me when she inquired with Mr. Freeman's company, that they were in the process of terminating him.
Okay.
If he has not.
All right. We want to make sure, don't want to send him back to a firestorm situation. So I will not order a stay away, but I will order no further contact with Mr. Freeman. So if he goes back and Freeman is there, he needs to go the other way, stay 200 yards away from him. No,
No, you can actually be quiet because it's not your time, so.
And Your Honor, I guess my question would just be whether or not Advanced Protective Services has to employ this gentleman at that location. Can he not be assigned to a different location?
it's a good question.
Uh,
Do you
Tim,
know that, Mr. Strobel?
Tim, can you unmute and see if there are other alternative locations from the employed at?
I mean, I guess the only question I have is, does Tim also employ the other co-defendant? Because if
No,
that's
Tim
the
does
case,
not,
then
no.
there's no
Tim does
need,
not.
there's no need for Mr. Newsom to be back at that location or for anybody to lose their job. We're here hearing from one side at this point. And I would say, because I was presenting both cases, the co-defendant, Mr. Freeman, has no kind of criminal history like this at all, and has had no chance to have his advocate respond at this point. So rather than make a decision that would ultimately maybe make Mr. Freeman not be able to return to his job, I'd rather there be a no contact period.
Thank you, Ms. Allen. I agree. We'll speak to Mr. Freeman, I hope immediately. Thank you.
All right, go ahead. I was going to say Mr. Advanced Protective Services, and I know that's not your name.
I apologize, Your Honor. It's Timothy Farrow,
Mr.
Farrow.
Okay, Mr. Farrell. All right, thank you. So what's going on with the employment of both of these co-defendants?
Well, only one of them, Mr. Newsom, is employed by me. The other individual is employed by another vendor. It's my understanding that the vendor, based on this incident, is going to terminate this individual.
Well, I'd rather not hear any of that from a
Yes.
third party,
Yeah,
but
yes,
I
ma'am.
appreciate it. The state would object at this point.
Yes, ma'am. It's my understanding that the client is extremely pleased with Mr. Newsom's performance and would prefer him to stay on the property as a security officer. And we have no issues whatsoever in finding him an alternate location if that's what the court prefers. But the client has requested that he stays on the premises. They are pleased with his job performance so far.
Okay. State, do we need to hear from Mr. Cook before I rule?
Yes, please.
I think that would
Let's
be
do that.
appropriate. This
Right.
is very one-sided at this point.
Right.
Yes, thank you. Yes,
Okay.
thank you. Your Honor, I'm glad to hear that Mr. Freeman has no history at the significant level that the cross defendant has. Mr. Freeman works, in fact, for the Waste Collection Company. I have not been in contact with them. I don't. That they will make their employment decision. I can tell you that I believe they both went to Grady. My client tells me he returned with a broken nose. That would explain the swelling and the cross defendant's hand that often happens when you hit somebody in the face. Our position would be, and it's my client's position, is that he was not the initial aggressor, and he was defending himself. I'm not sure how they both wound up in the elevator together. That was an unfortunate situation. We would be seeking, for my client, a signature bond at whatever level the court deems appropriate. I would hope the court would not order a stay away from that location. That I would think that would be up to the property managers and my client's employer. And I don't know that he's facing immediate termination. So
How old is Mr. Freeman?
My client is 44.
Well, it's
He also works, by the way, as a paraprofessional for the Atlanta Public Schools at Maynard Jackson High School. So he tells me, working with special needs kids, I'm trying to protect his job and give him a fair bond. And I don't think the two situations really compare once you understand the background of the previous or of the cross defendant.
All right. Well, wish I knew a little bit more. The company that Mr. Freeman works for is a maintenance company. Is that true, Mr. Farrell, or do you know?
Your Honor, Mr. Farrow doesn't know. He just employs Mr. Newsom as a security guard.
It was reported to me by the property manager that he was employed by the waste management company that collects trash in the hallways.
Okay. All right. Well, I want to hopefully get it right. Sometimes I do, sometimes I don't. We will have limited information and limited amount of time to kind of go through the situation, but I want to make sure that we're not putting them both back in a hailstorm of, seeing each other in the hallway, the elevator, whatever. Somebody has got to go for the moment. Someone has got to be off the property so that we can figure this out. I try not to order people away from places that obviously would affect their wallet and their eating, if it's a job and they have a decent job and they're willing to still and the employer is willing to still keep them if there's been an incident. Mr. Newsom is only 25, is very young, and Mr. Freeman is 44 and has another job, has two jobs. State, I think, and you tell me you think something different, I would let Mr. Newsom go back and Mr. Freeman stay away. Even though I know he doesn't have a history, but he has a second job, obviously. And maybe I don't know which is his main job.
This is his main job, Your Honor.
When I read the police report, Your Honor, and the documents in front of me, it's clear that Mr. Freeman went into the elevator and Mr. Newsom followed him into the elevator, and that's where the assault occurred. And that Mr. Newsom was the first person to lay hands on anyone by his own admission. And so that would be the reason why the state is requesting a stay away or no contact and pointing out the defendant's criminal history and the age difference.
Mm-hmm.
Your Honor, I don't know really what I want to say. If he is working security and he has a person who is trying to access
Sir, you can argue at a jury trial, or if there's a civil case related to the actions of your client. We're talking about bond today.
Exactly. We're talking about the likeliness of the reoffend and the person to come back and commit new crimes. Obviously, the circumstances surrounding and what his job duties were at the time go towards that. His job duty was to keep people away from unauthorized areas and to look after the site. That was part of his job as security. Therefore, if he finds someone that is trying to access an unauthorized area, it is part of his job and duty and in the scope of his course of work to escort them off the premises. That is part of his job description. So therefore, there's no reason to ask why he followed him into the elevator. That was the responsible thing to do as his job as a security officer.
Well, with all due respect, he's not in jail because he followed somebody into the elevator and did his job, sir.
He's in jail because after he escorted him out, the guy ran back into the elevator. That is what the witness said. That is what the witness statements we have. And then he made the comment.
That's not what the documents say. And I fail to believe that 2 days since this incident, you've had enough time to do a thorough investigation. So we can just continue.
All I have obviously is the arrest affidavit and the information that flows from that. And I haven't really objected because there's no real jury, but obviously a lot of what we've heard would be pretty classic hearsay. All I know is my client has a broken nose. He's 44 years old, with a fairly clean background. The cross defendant is 25 with an incredibly ugly, violent background. I
guess the one thing, and I don't mean to cut you off, Mr. Cook, because I do need to move on. We have a lot of cases today. And that is with the history and background of Mr. Newsom, and the employer wants to still employ him, and that's their prerogative. But I did hear that he has another location. So I'm going to have to ask Mr. Newsom to stay away from this location until we can be sure that Mr. Freeman is not going to be there. And so I'm going to just make that decision. You all can both, as counsel for your clients, apply for a modification of the bond. Things change or Mr. Freeman is no longer working there, then ask that he can go back and ask this employer, Mr. Farrell, to send him to a different location so that he doesn't violate any conditions of his bond. So here's what I'm going to do. I'm going to order a surety bond for Mr. Newsome because his history dictates that, and to make sure that he will return. I'm going to just go a little bit in the middle with a $1,500 surety bond for Mr. Newsome. And with that surety bond to stay away from 396 Piedmont Avenue Northeast, as long as Mr. Jordan put in the bond order, as long as Mr. Reginald Freeman, the co-defendant, is still working on those premises.
Your Honor, may I ask one more thing, that if the owners, instead of getting fired, if they issue a criminal trespass to Mr. Freeman, would that also allow Mr. Newsome to go back to the property?
Well, if that is orders entered and he's not supposed to be on the property, then certainly.
Okay.
Mm-hmm.
Thank you, Your
Yeah.
Honor.
Yeah. So as long as Mr. Freeman is not there, or he's trespassed from not being there, or fired, whichever way it goes, then Mr. Newsome can go back to that location. But I don't want to put them in that situation, either of the gentlemen. No drugs, alcohol, guns, or weapons while on bond. And that's all I'll order for Mr. Newsome, the 1,500 surety. And then on Mr. Freeman, and let me call that case, which is position 13. I think he's sitting on the front row. Is that correct, Deputy?
Yes, Your Honor.
Okay. And that's 24 CR 006989J with Reginald Freeman, charged with 1 count of battery with no criminal history. Is that correct, State?
I saw an arrest in 2001, Your Honor.
Oh, okay. Over 20 years ago. All right. And so with Mr. Freeman, I'm going to order a $1,500 signature bond. And that signature bond, I will order that through the jail. And he is to stay away. I'm sorry, have no further contact, rather, with Mr. Newsome. And I'm not ordering the stay away yet in regards to Mr. Freeman, because I have the stay away with Mr. Newsome. So depending on what happens, Mr. Freeman would have to abide by any other orders if he needs to stay away from the property, but I'm not going to put a stay away in place for him in this order. No drugs, alcohol, weapons, or guns while on bond as well. All right, so that should do it for both cases. Any questions, counsel?
Nothing.
Nope, everybody clear?
Yes, Your
All
Honor.
right, thank you for your time.
Thank you.
All right, thank you. You may be excused. Who's raising their hand?
Mr. Freeman.
Mr. Freeman, do you have a question about your bond? You have a signature bond?
No, ma'am, I actually have a statement to make.
No, you don't. No, you don't. This is not your trial. You're getting a signature bond, you're getting out, and I know your attorney's gonna suggest you be quiet.
I'm going to suggest that you can.
All right,
Oh, he disappeared. Okay.
you got it. Okay.
Okay.
All right, thank you. All right, everyone
Thank you.
else is dismissed in this case.
Yeah.
Thank you.
Thank you.
Mm-hmm.
So who did we just do?
We did 2 cases in one, and I apologize. I just kind of got rid of both of them. On 22 Newsome, that's a $1,500 surety. And then 13, Mr. Freeman, it's a 1,500 SOB jail.
Thank you.
Okay.
Next, Your Honor, we have position number 27 and 28, Mr. Wilkinson.
Okay.
27 and
You're
28.
in this situation,
Judge,
All right.
Mr.
in the situation, I just reached Maureen McLeod. She's out of Judge Taylor's courtroom now. So she could stand in for Watson Cafe in a pinch. And she's aware of the guy's name. She's calling Mr. Jordan now at my request.
Oh,
So,
okay. Mr. Jordan.
Attorney Watson Cafe is not available today, but Ms. McLeod did say she can log on. So But
Okay,
so Mr. Wilkerson, we can do someone else. She can interview him.
okay.
Go back to the other seat. Go back there. Next, we go to position number 2, Mr. Alexander Allen.
Okay. This is 24 CR 0069994Y, Alexander Allen Vinson, charged with 1 count of willful obstruction of a law enforcement officer and 2nd count of criminal trespass. Pretrial?
2024 possession of marijuana, 2018 wrongful use of meth or amphetamine, 2016 child neglect. I think got those out of the army. It has a felony bench warrant, so you're gonna have to sit tight for a minute. That's it.
All right.
Your Honor, this is an incident from October the 9th. This takes place at 3019 Kentucky Court, apartment 4, specifically at 6 a.m. Police were notified that someone who should not be in the vacant apartment there, apartment number 4, was at the location. Police responded to the location. The door was open. Again, no one should have been occupying the apartment. As police went inside to clear the apartment, the defendant came running down the stairs and out the front door. He ignored verbal commands to stop and was detained after a short pursuit. We would ask for a $2,000 bond, a surety bond, Your Honor. Stay away from that location there at Kentucky Court, and no drugs, alcohol, or weapons. Pretrial, can you give information about what the felony matter is?
I didn't make a note of it. I just made a note. I didn't write down the charge though.
Right.
But
Is
it gonna be a
Fulton County?
while. Yeah.
Okay, thank you.
All right. PD Cook?
Yes, Your Honor. My client's 27 years old. He is homeless. He is from the area, and his dad lives in the area, so I don't think there'd be any problem with him coming to court. Obviously, he's got other issues, bigger fish to fry. We would ask for the lowest possible bond, given that he is homeless, he has no income, it's not working, employment prospects, 0 at this point. Beyond that, we'd leave it in the court's discretion.
Okay.
So his open case in felony court, Your Honor, that he's got a failure to appear on is a controlled substance case from May and June of this year. So he's in violation of his bond and he failed to appear on that case.
All right. You don't have any services, Mr. Cook, to offer him?
I can, since he's probably going to be in the facility a while, I will certainly ask social workers to visit and see what they can provide.
Okay. I will order that $2,000 surety bond. That's $1,000 on each of the charges. And I'm going to order stay away from that 3019 Kentucky Court, apartment 4. Actually, is that a apartment complex? I was gonna order him to stay away from the whole complex.
It's unclear. I tried to look it up online. It's not clear to me that it's a complex, Your Honor. So I think just the 3019 Kentucky Court, apartment 4.
All right. So if it is just an apartment building or a complex, stay away from that area as well as that apartment number 4. But it's probably in a building, at least of 2 or more apartments, to stay away from there. No drugs, alcohol, weapons, or guns while on bond. So that should be it.
Next, we go to position number 12, Mr. Frost.
Yes.
Mm.
12 is 24 CR 0070018. And that's Gregory. Are we pronouncing it Foss? Fose? Don't know if that's correct. Foss. Okay. Charge of one count of loitering, prowling, second count willful obstruction of a law enforcement officer, third count giving false name or other information. Pretrial.
18. Last arrest was last month. Cobb County obstruction. On probation out of Douglas County. Possession of meth, possession of drug-related objects. Wanted out of DeKalb County. 2 probation violations from last year. 2023 trespass obstruction conviction. 2023 giving false name conviction. 2021 possession of meth, possession of drug-related objects conviction. 2014 possession of meth, possession of a Schedule 2 obstruction conviction. That's it.
All right, State.
Your Honor, this is an incident from March of last year. There's been an outstanding warrant for this young man, and he's clearly been bouncing around from jail to jail for a period of time. So it's taken a while to catch up with him. But ultimately, police were called to 161 Senoia Road. That's the Temple of Prayer Church at around 4:30 in the morning to report that there were 2 individuals that were just standing in the doorway there. The church is obviously closed, and it was concerning to people. Police came to the location. They encountered the defendant and a young woman. The young woman was cooperative and said that they'd just been charging their phones. The defendant fled as soon as backup arrived after he'd given a false name. He said he actually used the last name of the young woman he was with. He said his name was Austin Keys, Keais, and then fled into the woods. So once police identified the defendant, they issued a warrant for his arrest. We would ask for $1,000 surety, a requirement that he stay away from the church there on Senoia Road, no drugs, alcohol, or weapons while on bond.
All right. P.D. Cook.
Yes, Your Honor, my client is 31 years old. Given his situation, and in this incident was in March of 2023, I don't believe he would qualify for a signature bond from what I hear and understand. We would ask for the lowest possible bond. He is not employed at this point. Obviously, apparently has some holds going forward. So he's got a lot in front of him, and with little or no income. Nothing further.
All right, I'm going to order $1,500 surety bond. That will be 500 on each of the charges. I'm going to also order him to stay away from 161 Senoia Road, Temple of Prayer Church. Stay away from there. No drugs, alcohol, weapons, unprescribed medication, or guns while on bond. And that should do it.
We had a loitering and prowling and a willful truck. Which was your third? Third
one I had giving false name. No.
Oh, okay. Okay. All right.
Did I? Okay.
Okay.
I think they originally charged him as as an obstruction charge for giving a false name, and that just doesn't make any sense. So I changed it.
Okay. All right. Anything else?
We can go over to ACDC.
Good afternoon, Judge. This is going to be position number 7, Brown.
7. Okay.
Thank you so much, man.
This is 24 CR 006997C. Excuse me, and this is Chloe Brown, charged with 1 count of criminal trespass, damage to property. Pretrial.
Second arrest. 2015. I got armed robbery, obstruction, first offender.
Huh?
Your Honor, this is another dual arrest case. Mrs. Brown's co-defendant is position number 15, Mrs. Heath.
On that history?
Yes, you said that Miss Brown had how many total?
She's got
So-
a first offender conviction out of here, Fulton County. I think it's first offender from 2015.
But I thought I heard 17 to begin with. No.
No, I said second.
Second. Okay, because I thought, well, I didn't hear that much. Okay, sorry about that. Second. All right, yes, give me the history on Miss Heath.
I don't think, by the
Oh,
way, I
Your
don't
Honor.
think we have a conflict attorney for Miss
Oh,
Heath.
for Miss Heath.
I
Well, if Miss
requested it.
McLeod
But
is
we can
signing
go
on.
with Brown.
Okay, well, let's wait.
I'd like
Miss
to.
McLeod can sign on for her, I guess. Can she do her as well as the other one?
Your Honor, is there someone that the court?
Oh,
would-
there you go. Hi, Miss McLeod. Thank you. I think they have, what's the gentleman?
Mr. Wilkinson, yes, I have already spoken with him.
Are you all begging her to speak to Miss Heath?
Would allow us to
Yes,
go
sir.
forward completely. Yes, I would think that would be.
That's number 15.
They're begging for number 15 too, Miss McLeod. Can you do that or
Speak
no?
with her.
Okay. Your lucky day.
Yeah, the lucky day, right? Okay.
Not a conflict we caught before. Thank you.
Oh, okay. All right. So do we want to finish with this one or give her a second and go to someone else?
It's up to you, Your Honor.
Well, I'd like to take them together. We can get them out. So let's do someone else, deputies, and then we'll come back to her. Give Miss McLeod a second.
If ACDC will call me, I will speak with her.
Okay.
Okay, I'll put her on the phone, Ms. McLeod.
Thank you.
And you said it's gonna be Miss Heath?
Yes.
Okay, go ahead. No.
We can go with, position number 11, Mr. Davis.
Okay.
Davis. Yes.
Okay.
All right. I think they're telling me to take position 11 real quick, ACDC. And then I guess we'll come back to you.
Okay, not a problem. Thank you, Judge.
Thank you. 24 CR 00700B, Benjamin Davis, charge of 1 count of simple battery, 2 counts of simple battery family violence. Retrial.
Fifth arrest. 2018 theft by taking, entering auto. 2017 entering auto conviction. 2011 and 12 burglary arrest. That's it.
All right, thank you.
Your Honor, this is an incident from October the 9th. This took place at 960 Sells Avenue. That is the residence of this defendant's mother, Cindy Davis, who's also one of the victims in this case. Police were called to the location when someone reported that there was a dispute. On scene, witnesses, separate from the 2 victims in this case, witnesses reported the defendant had been drinking all day and had already had an altercation with the maintenance man. And as the evening progressed, he became more aggressive and began making threats to people nearby. The report details that during an argument between Natasha Burton, who is the girlfriend of Mr. Davis sitting in front of you, and Mr. Davis's sister, other family members tried to intervene. So Cindy Davis tried to stop this violence happening in her home, at which point the defendant in front of you pushed his mother down on the ground. And then it's reported by witnesses as well as Natasha Burton, the girlfriend of Mr. Davis, that he choked her during this argument. When we spoke to Ms. Burton today, she has changed her position and says she was not choked and she's not afraid of Mr. Davis. She also says that the argument, she corroborates the facts in the statements in the documents that we have, that there was an argument between Mr. Davis and his sister and her, Mrs. Natasha Burton, and that mom, grandma, tried to intervene. Cindy Davis, that's her residence. She reports that Mrs. Burton and her son stay with her from time to time. but ultimately they don't live there. She also confirmed that there was an altercation between Mr. Davis and his sister there in mom's house, and that her son pushed her down on the ground. She reported that her son gets very angry and violent, especially when he's drinking. And the police were at her house just as recently as last week. She is requesting no contact and to stay away from the residence. So, Your Honor, we'd ask for a $2,000 surety. We've got two different victims here who obviously have different positions, and that's fine. But this is a residence there at 960 Sells Avenue. That's the home of Cindy Davis. So we would be requesting the order for bond on Mr. Benjamin Davis to require he stay away from that location and have no contact with his mother, Cindy. Obviously, he and Natasha Burton, his girlfriend, will continue to have contact. We'd request it be no violent contact, and she's going to have to stay away from that location as well. No drugs, alcohol, or weapons while on bond. And if you would sound for Mrs. Cindy Davis and Natasha Burton, if they're on the Zoom. Thank you.
All right. Cindy Davis or Natasha Burton? Nope.
Yes, Your Honor.
Oh, okay, Miss
This is
Davis.
Miss Davis.
I'm sorry?
I said, this is Miss Davis.
Yeah, do you wish to address the court today? If you do, you have to turn on your camera and be sworn in.
No, Your Honor.
All right,
I
thank
just
you.
would like for Mr. Davis to be.
Say yes or no, and if it is, I said, then I would have to swear you in before you speak. So
Oh,
if you want to
yes,
say
Your-
something, then let me know that.
Okay, yes, Your Honor.
Raise your right hand for me. You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
Okay. And are you in fear of Mr. Benjamin Davis?
No, I'm not in fear of Mr. Davis. I just want him to get counseling. If you could recommend that he get counseling, please.
All right. And so do you want to have any further contact with him in the near
Not right
future?
now. In the near future, yes, but not right now.
Okay. All right. Thank you for that. Any cross-examination?
Mrs. Davis, just briefly, you told our staff that the police had just been to your house in the last week for another incident.
Yes, ma'am.
Your daughter that was also involved in this situation, is she also an adult?
Yes, ma'am.
Does she live with you?
Yes, ma'am.
And does she have children in your home?
No, ma'am.
Okay. Do you have any other children living in your home?
Yes, ma'am.
You have children who are juveniles under the age of 18 living with you?
Yes, ma'am.
And who do they belong to?
They belong to my oldest daughter. They go to school around the corner from me.
And would it be beneficial for you to not have violence like this in your home regularly?
Yes, ma'am.
Thank you. Those are all the questions I have.
All right.
We would request, Your Honor, that the defendant be ordered to enroll into a DVIP program within a certain amount of time after his release.
All right. Is it PD Cook or McLean?
It's mine, Your Honor.
Okay.
Your Honor, my client's 32 years old. We have no objection to stay away or no further contact at this point. He is not working. We'd like to keep the bond as low as possible, preferably around $1,000 surety bond. We would object at this point to the DVIP. Nothing further, Your Honor.
Okay. And I forgot again, Mr. Benjamin is how old? Mr. Davis?
32.
32. And this was his fifth arrest, correct? Is that correct, State?
Yes, Your Honor, the conviction history and criminal history for this gentleman doesn't really include any violence, just a lot of thefts. His last arrest was for loitering and prowling, I see, in 2018. He's got a burglary, entering auto, things like that.
Okay. And so let me say this, or ask this rather, Mr. Cook, you know, if he has somewhere else to go stay?
He said he did, yes, because I discussed the possibility or even the likelihood that there would be a stay away. But he's got friends in the area. He wasn't specific, but he said he could handle that.
All right. I'm going to give him a $3,000 signature bond. And I guess I will give him that through the jail. And that'll be 1,500 on each. And I will order him to stay away from 960 Sales Avenue. No
Judge, this
further.
is
I'm
Davis,
sorry.
right?
Yes.
I don't think you can do family violence
Oh,
through the
I'm
jail.
sorry. I just looked at family violence. I
Yeah.
just saw simple battery.
You could level
Pre-trial.
one it. You could level one it.
Yeah. Pre-trial level 1. I just looked at family violence. Pre-trial level 1. And then stay away from Sales Avenue, his mom's house. No further contact with her or the sister, Natasha Burton.
That's his girlfriend.
I'm sorry, girlfriend.
Just stay away from mom in that location.
And then no further violent contact with Miss Burton, correct? Okay.
Correct.
I got it. And no drugs, alcohol, weapons, or guns while on bond. And I guess that'll be it for now. You know, what I'll do is I'll add, let me give him a 2-day anger awareness course through pretrial. I'll just do that for now. They can do DVIP later. All right.
Position number 15, Heath.
We were starting on the other as well, weren't we?
Yes, that's Chloe Brown. I'm not sure of
Chloe Brown. Chloe
We can
Brown
do her
was in the
next.
chair. Okay.
Yeah, we can do her next, Judge.
Okay. All right. So this is 24 CR 0070038 Brenda Heath, charged with 1 count of battery. Retrial.
Heath.
Yeah.
9th arrest. Criminal trespass, simple battery, obstruction, terrorist threats, criminal interference with government property. Was the last arrest. I think this was level 1 too.
Okay.
All right, that's it.
All right. State.
This is an incident that occurred on the 10th of October at about 9:30 a.m. Police were called to a fight at 1031 Grant Way. On scene, the 911 caller, Mrs. Chloe Brown, who is position number 7 and the co-defendant to Mrs. Heath. She reported that she and her boyfriend were arguing and that his mother, Mrs. Heath, so be clear, Chloe Brown, co-defendant, and her boyfriend's mother, Mrs. Heath, are in front of you. Mrs. Heath overheard arguing happening in her home and went into the bedroom, and Mrs. Brown reports that Mrs. Heath struck her multiple times. Mrs. Brown was seen to have scratches on her face as a result of the rings that Mrs. Heath wears. She's had an injury to her lip. The parties were separated by people there on scene. And unfortunately, Mrs. Chloe Brown went outside and picked up a part of a grill and started smashing it against Mrs. Heath's vehicle, damaging the rear passenger side window. And for that reason, they were both arrested, Your Honor. We're asking for, I guess, clarification that the 1031 Grant Way is the residence of Miss Heath. And if that's the case, we would request a stay away for Chloe Brown, no contact whatsoever, no drugs, alcohol, or weapons for either of them. We'd ask for a signature bond through pretrial on Mrs. Heath. And one moment. Mrs. Brown is the one who's got a first offender conviction for robbery from 2015. So we'd ask for the same bond, but a surety bond. Again, no drugs, alcohol, or weapons, to stay away from that location if it's Mrs. Heath's home, and no contact. Thank you.
Okay.
Your Honor, we are okay with the state's recommendation for bond for my client, and this is her home.
Okay. All right. So for Ms. Heath, which is position 15, we'll give her a $1,500 signature bond through pretrial level 1. And no further contact with Ms. Chloe Brown. And I guess that would be it. No drugs, alcohol, weapons, or guns while on bond.
That would be it, Your Honor.
All right, that's it.
Thank you.
Your Honor,
Thank you, Your Honor.
can we do
All right, you're welcome.
Ms.
We didn't-
McCollum's client position for 27 and 28?
Can I just go ahead and rule?
Well,
Can I
excuse me,
rule real quick
we
on-
didn't get through Chloe Brown. We didn't
Yeah, I
get-
was gonna
Judge,
rule
this
real
is
quick on
position
Chloe
7,
Brown.
Ms. Brown.
8.
Okay,
Position 8.
okay, thank you.
All right, Ms. Brown, we're gonna give her $1,500 surety bond.
I think that would be backward from the state's
I mean,
recommendation.
hold on. I'm on the wrong Brown.
Yeah,
There are a lot of them.
Chloe
today.
Brown's number
Here it
7.
is, Chloe, right.
Hey,
Sorry.
I'll close y'all out.
I'm sorry.
She's not talking to you, Judge.
I'm
Oh.
talking to the jail.
I was listening. All right, so position 7 is Chloe Brown.
That is correct, Judge.
Okay, I'm sorry, I was looking at the wrong Brown. And on Chloe Brown, this is her second, so 1,500. They're getting the same bond, correct?
I believe the state recommended a signature bond. That's what we would be seeking.
No, I requested a surety bond from Mrs. Brown.
Oh, did you? I'm sorry.
I did. And she needs to stay away from 1031 Grant Way.
We would be seeking a surety, a signature bond, Your Honor. But
This was
no,
her
no,
second, Ms. Brown. Is that correct, State? Wasn't her second?
Yes, she's got a first offender conviction for robbery.
oh, sure.
I'm going to give her a $1,500 signature bond. And to obviously stay away from Miss Heath's address and no further contact with Miss Heath. No drugs, alcohol, weapons, or guns while on bond. A signature bond through the jail. And that's it.
Thank you.
Thank you, Your Honor.
That
Judge,
was
correction. Judge, excuse me, for Ms. Heath, you gave her through pretrial, or was it through the jail for Ms. Heath?
On Miss Heath, I gave hers through the pretrial level 1.
Thank you, Judge.
What was the amount on each?
1,500 on each. 1,500 on both defendants. 1,500.
And Brown was through the jail?
Yes.
Can we go to Ms. McLeod's other client?
I'm sorry.
Can we do Ms. McLeod's client?
Oh, who's the other one?
Position 27 and 28, Mr. Wilkinson.
Oh, that's right. 24 CR 006986G, Alonzo Wilkinson. 28 is 24 CR 007012G. First case, 1 count of criminal trespass. Second case, 1 count of simple battery.
13, got an open case out of Fulton, trespass, damage to property. It's 21 CR 005-228G. Another open case for trespass. Open case out of Clayton, trespass, simple assault. Criminal damage to property, interference with government property. Open case out of DeKalb for obstruction, interference with government property, pedestrian improperly probably crossing the road. Another open case out of DeKalb, trespass, possession of drug-related objects, possession of meth. Was arrested this year for trespass, went to pad. That's it.
And so, Your Honor, just for the court's clarification and information, this case came in with the position that is the simple assault from October the 10th. Police were called to 1870 Piedmont Road. That's the Starbucks. This is position 28 on the docket. There at about 9 p.m., the police were called because of an assault. The defendant is homeless, and the victim inside the location, his name is Jacob. Last name is Avi Hashira, Avihashira, reported that while he was inside the location waiting on his order, the defendant approached him, mumbled a few words at him, and they had a brief exchange before the defendant threw the contents of his cup on the victim, wetting his clothing. An employee there at the location was a witness and reported to police that he saw the defendant walk up to the victim, throw the contents of his cup on him, on his body, and then flee. Police located the defendant behind a nearby building, and he was arrested. He had just been released from the Fulton County Jail in May to the PAD program, which, as you know, is when the state has decided to not file an accusation and instead release someone to a PAD program because they're clearly in need of services. But it looks like the gift of an unsecured judicial release in May for a criminal trespass at the Piedmont Road gas station. That's 1896 Piedmont Road, and that was on the 14th of May, 2024. So that's position number 27. He was there on the premises and had already received a warning. That gift of the access to PAD and services wasn't really helpful. You also did just hear that this gentleman has an open criminal trespass case. That 21 CR 005-228G is for breaking windows in a townhome complex where he doesn't live. He's got a criminal damage to property in the 2nd degree out of Clayton County from 2022 that's open, felony drug objects, and criminal trespass in Doraville from 2023. And so, although this gentleman is in need of services and seems to be committing some similar acts and is related to maybe some drug use or substance abuse, being part of a program like PAD isn't really helping him. And so we went ahead and filed that accusation today from May, since he's no longer going to be eligible for it. So the 2 cases in front of you, one from May and one from October, we'd ask for a $2,000 surety, one on each, Your Honor. He has unsecured judicial release on the criminal trespass, which we now believe should be surrendered. We'd ask for that to be converted to a $1,000 surety and stay away from the location. And then the same $1,000 surety and stay away from the Starbucks in position 28, that's 1870 Piedmont Road.
All right, Mr. Cloud.
Your Honor, the state has stated that my client is homeless. He clearly does not have the wherewithal to pay for a $2,000 bond, Your Honor. I understand that he does have some open cases, but I would ask the court to take his circumstances into consideration. As the state said, he was released to PAD. He tells me that actually he was the victim here because he tells me that the gentleman in question came after. He maintains that this was an accident when the water got on this person and that he apologized, but this person chose to chase him down and throw stones at him. So, you know, he was trying to get away, and this man ran after him and stoned him. So I would ask the court to take all of that into consideration in setting his bond, Your Honor. There was no actual damage to this person. Some water spilled on them. At least that is my understanding from what was said by the state and also from my discussions with my client. Nothing further, Your Honor.
On the first case on 27, I'm gonna order the $1,000 surety bond. On that particular case, no drugs, alcohol, weapons, or guns while on bond. And then on the second case, position 28, with the simple battery, I'm going to order $1,000 surety bond on that case as well. Stay away from the Starbucks on Piedmont. And was there a stay away on 27?
Yes, Your Honor, that would be 1896 Piedmont Road. That's a Shell gas station.
All right. Add that. And then on the 28 on Piedmont Road, the Starbucks, stay away from there with a 1,000 surety.
Thank you.
All right. And no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, you may. Thank you. Have a good weekend.
Thank you. The same to you.
Number 16, Henderson.
This is 24 CR 0070048, Autumn Henderson, charged with 2 counts of battery family violence. Pretrial.
8. Last arrest was in July. Ag assault, possession of a knife or firearm during the commission. Trespass, damage to property, obstruction. That's open in Superior Court. 24 PI 005318. Got an open trespass, damage to property. That's simple assault. Family violence is 24 CR 003-262H. He has a bench warrant and like 5 juvie cycles. So I think this is the 3rd adult arrest. That's it.
Thank you, Your Honor. This is an offense from October the 8th. Police were called to 3260 Dodson Drive Connector. That's in East Point. This is a dual arrest. Clifton Kendrick, excuse me, is the co-defendant. He came through SEA yesterday. I'm going to start with her criminal history. She does have an active failure to appear on an open case in state court involving the same victim. It's a damage to property case, although it is still domestic violence. She has an order in that case, 24 CR 003-62H, to have no contact with Clifton Kendrick. So her new case, that was from May of this year. Her new case, the one in front of you, October 8, 2024, is a violation of that bond. She also has a SOB through the jail on that case, Your Honor. In July, she was arrested for an assault on the same gentleman, Mr. Clifton Kendrick, and now has an aggravated assault case in Superior Court. In that situation, she stabbed him with scissors. That's 24 PI 005318. She's on bond out of the Superior Court for that case as well. So this incident on the 8th of October, police were called to this location in East Point where they spoke with both parties who were apparently fighting. They also spoke with hold on. one of the sisters of these folks. I believe the gentleman, Mr. Kendrick's sister, but I'm not sure. Anyway, there were witnesses to this assault, both of the individuals present in violation of the bond that this young lady is on already. Mrs. Henderson in front of you reported to police that Mr. Kendrick wouldn't let her leave the location. And so to protect herself, she got a screwdriver to scare him. She reports that the defendant held her down and pulled her hair. To defend herself, she struck Mr. Clifton Kendrick with a screwdriver, causing a laceration on his arm, and she bit him, causing redness and bite marks on his chest. Mr. Clifton reported to police that he was just trying to restrain Mrs. Henderson and keep her from hitting people and hitting him. The sister whose residence this is, because this is not a residence where either of these people live, reported that she was trying to get these folks to leave because they're always fighting, and she doesn't want this in front of her children. So Mr. Clifton Kendrick just came through with his own case, but in this case, Mrs. Henderson is not just in violation of 2 different bonds she's on for assaults on the same gentleman, but she's charged with the battery, Your Honor, 2 counts. 1 for striking him in the shoulder with a screwdriver, which could have been a felony had he actually had some other injuries, as well as biting him on his chest. Based on the history and the fact that she's currently on bond and in violation, showing that she disregards the court's order in general, we'd ask for a $3,000 cash bond, Your Honor. Again, no contact with Clifton Kendrick. Stay away from wherever he may live or work. No drugs, alcohol, or weapons. And the DA's office has been notified, as well as the court in H, the Division H, where her open case is from, that she's got a new case. Thank you.
All right.
Your Honor, while the state was speaking, I was attempting through chat and by telephone call to reach Mr. Cook. Who represented Clifton Kendrick this week?
Who you
Mr.
asked?
McLeod represented Kendrick yesterday.
Who, Mr. Jordan?
Ms. McLeod. So
Oh.
he was represented by conflict. Okay.
I'm sorry, by whom?
Thank you, Mr. Jordan. He said
Attorney
Mrs. McLeod
McLeod?
represented the co-defendant, so you guys should be fine today.
We are. I just wanted to double check on that one. Make sure we didn't mess up. Thank you.
All right. You going ahead, Mr. McLean?
Thank you, Your Honor. My
Man,
client, Ms. Henderson, is studying her high school classes online to have her GED or high school diploma and then go on to be a medical assistant. She works at Popeyes and has done so for a short period of time. Before that, she worked at a Taco Mac and worked at another place. So she is quite industrious. I understand the state's point about the history of arrests is concerning, and we would ask the court to set a bond that would be as low as possible. If a signature bond is not realistic, then we would just ask the court to go as low as it can on the surety bond.
I'm going to order with her history a $2,000 cash bond. I'm going to order, that'll be $1,000 on each. Going to order stay away from the 3608 East Point address. No further contact with, is it Clifton Kendrick? Is that the right victim?
Yes, Your Honor.
No further contact, stay away, no drugs, alcohol, weapons, or guns while on bond. 2,000 cash.
Thank you.
What was the stairway address?
It's 3260 Dodson Drive Connector in East Point.
Okay, thank you.
All right, who do we have?
Position number 3, Mr. Court.
24 CR 0069993D. Azizi Accord, charged with one count of criminal trespass.
2024 probation. On probation for trespass, damage to property, battery. It's 24 CR 000277D. Also on probation for cruelty in the first. 18 SC 1611117. On probation in Cherokee County, criminal attempt to commit a felony. Gwinnett County, possession of tools for the commission of a crime and arson. Open simple battery in public transit vehicle or station. Open trespass as well from May of this year. 2013 ag assault, obstruction, conviction. That's it.
Your Honor, this is an incident from the 10th of October at about 3 p.m. It's very simple. This defendant has an active ban that's in place for a year from MARTA. He was seen and identified being on the premises, of the MARTA Civic Center station. That's 435 West Peachtree Street. The defendant just pled guilty in April on a family violence battery case from this year. He's got an open battery on a transit official. And you just heard about arson in the second degree, cruelty in the first degree, aggravated assault, as well as burglary. We'd be asking for $1,000 surety, no drugs, alcohol, or weapons. Stay away from all MARTA locations. And we'd ask for a BHET, Your Honor.
Okay. Okay, is this Mr. Cook or McLean?
Yeah, it's mine, Your Honor. Yes, I think from what I hear, would be restricted from a signature bond. So we have no objection to that, and I'll get with the social workers and ask for the BHET.
All right. 1,000 surety, BHET. Stay away from all MARTA, still under the 1-year ban. No drugs, alcohol, weapons, or guns while on bond.
Thank you.
Number 24, Peterson.
This is 24 CR 0069855E, Courtney Peterson, charged with 1 count of simple battery. Pre-trial. Pre-trial.
Your Honor, I have her history.
Step away, you got the history. Okay.
She's actually in pretrial diversion, I believe. The only other arrest she has is November 2022, which is a marijuana possession. And I believe she was sent into diversion in July of this year. So that may be a case that ends up getting filed if that's something that they want to move forward with. This is an incident from October the 10th. At 1 p.m., police responded to 680 Lee Street. That's the West End MARTA station, on a report of an assault. There they met with the victim, Ruth Crumbly. She's 62 years old. She reported that the Black woman who she did not know had just walked up to her and struck her in the face with an open hand. The defendant in front of you, Mrs. Courtney Peterson, was located and spoken with, and a show-up was done with the victim. She positively identified the defendant as the person who just assaulted her at the MARTA station. We'd be asking for a $1,000 surety, Your Honor. Stay away from all MARTA locations. Absolutely no contact with Mrs. Ruth Crumbly, and no drugs, alcohol, or weapons while on bond.
All right. PD?
Your Honor, my client is 24 years old. She is a caregiver for her grandmother. That is not a paid position, but it does take quite a bit of effort and time. She is in disagreement with the facts as alleged. We would ask the court to consider a signature bond. She is 24.
And then you had the PD diversion, right, State?
She has a case, much like a pad case, where we did pre-accusation diversion. Doesn't seem to be working real well. So she's got a case that hasn't been charged, that's been sitting and waiting. And that may be something that the diversion unit comes off of based on a stranger assault at the MARTA station.
We'll do a $1,500 surety bond. No drugs, alcohol, weapons, or guns while on bond. And are we staying while the ban from all MARTA would still be in place, correct?
She doesn't currently have one. That's what we're asking for.
Oh, I thought you had one as well. So a ban or from all MARTA while on bond, stay away from MARTA. No drugs, alcohol, weapons, or guns while on bond.
Next, we
Zero.
go to position. Next, we go to position number 19, Mr. Jeffries.
Was there no contact on that last case?
Oh, I forgot to say that on the last one. Yeah, no further contact with the victim.
Her name's Ruth Crumbly.
Ruth Crumbly. All right, and we're on position, is it 19? This is 24 CR 0070006D Corey Jeffries. Charged with 1 count of battery, family violence, 2nd count of criminal trespass and damage to property. Pre-trial.
Hold on real quick. Somehow I skipped him. I don't know how. He got 19 total, 2023 ag assault. Hold on. Sorry, stupid. Hold on. All right, last was 2023 ag assault, possession of a firearm during a commission, possession by a convicted felon. That's open, 23 CP 215718. Got a 2021 fade to appear. State, you can get arrested. This crap keeps spinning. I'm not understanding why.
Ultimately, Your Honor, the case in front of you is from September of last year, so it's subsequent to the case that he's got open in Fulton County Court for an aggravated assault in Superior Court, excuse me. So he's had a warrant out for a period of time. Police were called at 9 p.m. to 3223 Talon Lane, Tallon. That's Talon Lane Southwest. There, they spoke with the victim, Amber Spears, who reported that she got into an argument with the gentleman that she lives with because money was missing from her closet, and she questioned him about it. He became angry, and as she walked out of the room, he slapped her in the back of her head. That's the battery, family violence. He then struck her, and when she told him she needed to leave, he pushed her down on the ground. When she tried to get up, he pushed her down again. And she had bruising on the left arm when she spoke to police. Of course, he'd left the location, but before he'd done so, he damaged her television. And that was seen by police on the scene as well. The victim reported that his sister picked him up before police got there. She said that they share no children, they do share a child, but she claimed that nobody was present to witness that incident. We've tried to get in touch with her today. That's Miss Amber Spears, and haven't been successful yet. But based on the fact that he's out on bond, and this would be an assault after he's out on bond for an aggravated assault, we'd ask for a $2,000 surety bond, Your Honor. No contact with the victim, Amber Spears. Stay away from wherever she may live. I'm not sure if it's the same address since it's been a while. And no drugs, alcohol, or weapons while on bond. Thank you.
Mm-hmm. PD McLean?
Your Honor, excuse me, my client is 28. He, I believe, the main point we would make in asking the court to consider a signature bond is that the case is at this point a little over old, and I don't think that's necessarily through anybody's fault. It seems like it could have been. I don't know if the ag assault case. Let's see. That took place. That was alleged to have occurred something like 9 months before that. So the main point I would make is that it seems like he stayed out of trouble for a year, a little over a year, and we would ask the court to consider a signature bond on that basis.
All right. Guess I will do the $2,000 signature bond. I'm sorry, surety bond. And that'll be 1,000 on each for the 2,000 surety. We've got to stay away from the incident location. And didn't write down the victim's name.
Her name is Amber Spears.
Okay. No further contact with Amber Spears. No drugs, alcohol, weapons, or gun while on bond.
Thank you.
Mm-hmm.
Number 21, Lee.
'24 CR 0070007 J. Is it Danica Lee charging 1 count of giving false information?
17. Got an open forgery in the first theft of services. Financial transaction card fraud. Identity theft fraud. 23 SC 186619. Open 3 counts of forgery in the second, 5 counts of financial transaction card fraud. Possession of a firearm by convicted felon. Possession of marijuana with intent. It's 24 SC 003858. Also has a bench warrant. That's it.
Your Honor, police were called to 12795 Wingate Trail at about 10 a.m. This is a location in Johns Creek where someone reported possible suspicious activity or fraud that they were investigating by a tenant. On scene, police made contact with the defendant, Mrs. Danica Lee, at the door. She provided a false name, Frenchie Boyd, I believe a false date of birth as well. She was detained while police looked up her information, and when they told her they were verifying that she had an active warrant, she quickly revealed her real name, and the rest is history. You did just hear she's got a series of convictions for fraud as well as firearms, and she's got open failure to appear. We'd ask for a $500 cash bond, Your Honor, and no drugs, alcohol, or weapons while on bond. She's got other things she's going to have to deal with.
And what was the state's recommendation?
Said $500 cash.
Okay. All right, McLean?
Your Honor, we would ask the court to consider either a signature bond or a $1,000 cash bond, and instead, given that it is a very simple case, that it is 1 count of false information.
All right, I'm gonna order the $500 cash bond. No drugs, alcohol, weapons, or guns while on bond. And then was there to stay away in the victim?
No, Your Honor.
Okay. And I guess no drugs, alcohol, weapons, or guns while on bond. Is that it?
Yes, ma'am. Thank you.
Huh?
Next, we have position number 9, Mr. Brown.
This is 24 CR 0069998E, Nicholas Brown, 1 count of theft by taking. Pre-trial?
Third arrest. Last arrest was in August, theft by taking. It's 24 CR 006-097E. On probation in the cab, pointing, aiming pistol at another. That's it.
State?
Your Honor, this is an incident that occurred August the 28th. He had just been released on the same day, or this is an incident that occurred on the same day, basically, in and around the same day. He's currently has a $3,000 SOB and 24 CR 06097E. That is also a theft by taking. Police were called because of a missing package on the porch at 526 Cogdell Trail. That's Cogdell. This is in Milton. The victim, Mr. James Schroeder, reported that his wife was expecting a package of new electronics, including an iPhone. FedEx reported that they delivered the item at about 9:30 a.m. that morning. Video footage on the porch revealed the defendant drive up in his personal car, get out and go on the porch and take the package. Police spoke to the yard man who reported that he'd seen the defendant drive up and nonchalantly walk up on the porch and take the package, and he didn't think anything of it since people contract with Amazon and often use their private vehicles. Information about the vehicle was obtained based on the surveillance, and it was revealed that the registered owner is the gentleman in front of you. His description, his unique outfit he had on when he took this package, as well as the facial picture of him and his driver's license, and the fact that on the same day, the same kind of theft had just occurred in Alpharetta using the same vehicle and wearing the same clothes. That would be his $3,000 SOB he's got right now. So it took a little bit of time for Milton PD to realize that he'd done the same thing in the next jurisdiction over, but they were able to identify him. So now he's got 2 identical cases. We'd ask for a $2,000 surety, stay away from the location, 526 Cogdell Trail, no contact with Mr. Schroeder, no drugs, alcohol, or weapons. And I'm guessing pretrial is going to come off that SOB. Is it through pretrial?
Thought so.
I don't know. I'll look it up.
Oh, okay.
All right.
Go ahead, PD Cook.
Yes, with regard to the criteria, the bond that my client gave me, we would have no objection to that, Your Honor.
Say that again, Mr. Cook. I'm
Well,
sorry.
we have no objection to the recommendation of the state.
And this one was Nicholas Brown. That was the 526 Cogdell.
Yes.
Okay. And the state was recommending
$2,000 surety. He's got a $3,000 SOB right now for the same facts on the same day. Clearly, he's in violation of that, even though they happened on the same day.
That's a SOB jail. Judge, you said that bond.
I did. Oh.
You might not have said it if you knew that the same day he'd committed the same crime in another jurisdiction in the same
I
clothes
know,
using the
geez.
same car.
Same clothes, everything. Usually I do cash.
Well, we wouldn't be objecting to that, but ultimately these were just committed on the same day and it took Milton PD a little longer than Alpharetta.
To get them together. All right, I'm going to make it a $2,000 cash bond. Stay away from the 526 Cogdale. No drugs, alcohol, weapons, or guns while on bond. That should be it.
Thank you.
Was that 2,000 cash?
Yes, 2,000
Okay.
cash, yes.
Next, we can go to position number 1, Mr. Adams. You need to go.
Okay. This is 24 CR 006995F, Javon Adams, 1 count of simple battery, family violence. Pre-trial.
4 total. 2022 DUI, 2016 petty larceny conviction. 2014 possession of a controlled substance conviction.
All
Your
right.
Honor, this is an incident that occurred August the 29th of 2024. Police were called to 998 Redford Drive at about 8 p.m. There they met with the victim, Mrs. Sybil Gill. She's here on the Zoom. She reported that her boyfriend became angry because she went out for drinks with some friends after work, and he used both hands to shove her multiple times in the chest around their house. She said that they lived together and they share two children. This is a simple battery. We've spoken with Mrs. Gill. She says that they are in a relationship and share 2 children. She wasn't interested in talking about the incident. This is clearly a traumatic, but also layered. I'm guessing she doesn't want to get Mr. Adams in trouble. This happened in August and he was just picked up. Of course, she says she wants contact and for him to return to the location. I don't see any similar kind of arrests in his history, although I do see an open DUI. We'd ask for a $2,000 SOB through pretrial. I think he's eligible for that. No violent contact and no drugs, alcohol, or weapons while on bond.
All right.
And if you'd sound from Mrs. Gill, she's here.
Okay, Ms. Gill. You wish to address the court today?
Hello, yes, Your Honor.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, are you in fear of Mr. Adams?
No, Your Honor.
You want to have any further contact with Mr. Adams?
Yes, Your Honor.
How old are your children?
We have a 5-year-old and a 10-year-old.
Okay. All right, any cross-examination questions?
Just briefly, Your Honor, Mrs. Gill, thank you for being here today. When you called the police on August the 29th, were you afraid? Why did you call the police?
It was just like too much going on for me, and it was the kids wasn't there and stuff like that. So that's why I called the police. It was just a lot going on. So
I guess I'm not sure. What does that mean?
what I just said.
Okay. A lot was going on. You were overwhelmed. What are we talking about? Your children weren't there?
No, my children weren't there.
That's why you called the police? I'm just trying to understand.
No, I'm putting that out there that my children were not there at the time of the incident.
Okay.
And I'm saying that at the time of the event, I called the police because it was a lot going on at the time. I felt like, if something needed to be de-escalated. So that's why I called the police.
Okay. So you went out for drinks and there was an argument afterwards and you felt like you needed some assistance in your house to de-escalate the situation with the defendant.
Yes.
Okay. Were you afraid at that point?
At that point, I was not afraid, but you never know what can happen with people. It was very heated, and me and Javon been together for 13 years. We came here together from New York, and it's just we're a young couple trying to keep it together. So it's a lot going on. It's a lot. So
had you been drinking that night?
I had a drink after work, but it was just, I normally don't go out and I didn't tell him. So it was just a lot. It was a lot
Is
going on.
8 p.m. late for you to get home?
Oh yeah. Yeah. I come home, I work a 9 to 5. I'll be home and cook dinner right after that.
And had Mr. Adams been drinking that night too?
I don't think so.
And what does he do during the day?
So he's a maintenance supervisor. We both work in condos. So he's in maintenance, I'm in property management, and he works a 9 to 5 like me.
And where were your children on this evening, August the 29th at 8 p.m.?
It was around like 7-ish when it really happened. And they were having like a pet rally. So my son is in football, my daughter is in cheerleading. So they're just having like a little get together over there. And we stopped by the house to pick up some stuff.
Okay. And that's where the argument occurred?
Yeah, because I didn't want to go to the thing. So I went out with my friends and he was going to the event and he was coming back picking up stuff and I was at the house and that's how that went.
Has anything like that ever happened before?
No, I haven't, had anything like that. No.
And about how
Especially
many
not
times did he push you during this incident?
At this time, I probably can't say I remember.
What?
I don't remember.
Oh, okay. Do you remember making the 911 call?
Yeah.
And you remember speaking to the police when they got to the scene?
It was just a lot. Like, you kind of like bringing me back to it. Like, I was kind of like pushing something, all these like stuff in the back of my mind. I'm moving forward. We've been talking about getting counseling because at the end of the day, whether it's a
So
relationship.
are you saying you don't remember or you just haven't wanted to think about it because you want to move forward?
Yeah. What you
Which
just
one?
said. I haven't been thinking about it because I want to move forward. So that's something
How are
I've
you going to
been
get counseling if you don't remember and you don't want to think about it?
That's something I need to talk about in counseling, not in court.
So you're just not willing to talk about the incident. It's not that you don't remember.
This incident is a personal incident, and I feel like this incident is something that, can be handled outside of court. I don't think it should be the court's decision at this point, on how we're going to move forward with our family and our kids and our lives. But, at the end of the day, this is court. You can make your decision, but that's where I'm at with it.
So ultimately, you're not going to be truthful and forthcoming about what happened during this incident. You think you got it. You guys are going to handle it.
I am being truthful, but you have your opinion. You have the right to that.
I think opinions and facts are different things, but okay. How old are your children again?
They're 5 and 10.
Okay. And how are they? You've got a boy and a girl.
Yeah.
Okay. And are you guys married?
No.
Have the children been legitimated by Mr. Adams?
Oh yeah. Those his kids.
So you went through a court process?
He signed both my kids' birth certificates. So
were the kids born in here in Georgia or in New York?
So my daughter was born in New York and my son was born here in Atlanta.
Okay. So the rule in Georgia is not signing a birth certificate. You got to go through a court process to legitimate children you don't have in a marriage.
I don't understand what that has to do with the case, ma'am.
I just wanted to know because I want to know
because like I feel like you're just like doing too much. Like I don't understand what that has to do with the case.
I'd love to explain it to you.
I really don't care for your opinion.
So Your Honor, at this point, we've asked for no violent contact, but I would, like to just point out on the record that you've got an individual who, while saying she doesn't remember, has admitted straightforward that she's not interested in talking about it, and she doesn't think it's the state's responsibility or our business, the crimes that are happening in our community in front of children. She wouldn't answer
not in front of children. On record.
Excuse me.
Not in front of children.
Excuse me.
Ms. Gill, don't interrupt. Ms. Gill, don't interrupt.
She had very specific memories about things like where she went, what was going on with her children, where they were meeting up, and what time it was, to correct me that it wasn't 8 o'clock, it was 7 p.m. But she has no memory of how many times her boyfriend pushed her around their house, but she did call the police. So at this point, we're not going to change our position about no violent contact, but the reason why I asked you about the children is that in this state, if you haven't legitimized your children and you have them out of wedlock, you have no right to visitation and custody. So you don't have to do anything to remove yourself from this situation if that's something you'd like to do. Mr. Adams doesn't have any legal right to those children. You don't need to be afraid of that. That's all.
Okay.
We'd ask
All right.
if it gets reset, Your Honor, that is open DUI 24 CR 003 694F be put with it, and that he be ordered to have no drugs, alcohol, or weapons while on bond.
All right. And the state's recommendation was what again? On the bond?
Anna, you was muted.
Oh, yeah, we didn't hear you.
Signature bond through pretrial and no violent contact. I apologize.
Okay.
Thank you.
No objection, Your Honor.
All right. I'm going to order the $2,000 signature bond through pretrial. I'm going to make it level 2. And I'm going to ask that he take a 2-day anger awareness course. I'm going to order no drugs, no alcohol, no weapons, no unprescribed medication, no guns while on bond, and no further violent contact with Sybil Gill, the victim. And I think that's it. Anything else? All right.
Hello?
Yes.
Yes, I just want to state that I did turn myself.
We're not going to do that about the case. If you have a question about your bond, I will answer that. Your attorney's going to tell you to be quiet.
Yeah, Mr. Adams, you've gotten a signature bond. Let's leave it at that. You take care of the case after you get out down the road through the normal adjudication process.
All right, thank you.
Next, we go to position number 18, Mr. Hughley.
No, I'm saying.
This is 24 CR 007-005J LaFrancia Hughley. Charge of 1 count of criminal trespass.
2023 trespass conviction. Another 2023 CT conviction. 2022, 2019, same thing. 2015 possession of marijuana conviction. That's it.
All right, state.
Your Honor, this is October the 10th of 2024. Location is 100 Lakewood Way Southwest. At about 12:50 a.m., police were called there. That's a Circle K gas station regarding an individual trespassing who had been previously given a criminal trespass warning. The defendant, Mr. LaFrancia Hughley, was on scene when police arrived, standing next to the gas pumps, talking to customers and refusing to leave. The clerk, Mr. Khan, provided police with the prior incident reports showing that he'd been criminally trespassed most recently, July the 14th of 2024. The defendant was arrested. You just heard that his prior recent arrests are for the same facts. We'd ask for $1,000 surety and a stay away from the Circle K at 100 Lakewood Way Southwest. No drugs, alcohol, or weapons while on bond. Thank you.
Okay. P.D. McLean. McLean. Can't hear you.
Your Honor, just this second received a chat from his sister. Let's see, I can answer. Okay, got it. Your Honor, my client is 33. He needs a social worker. He's struggling. One can tell from the pattern here that he needs some help. So we're going to try to get him set up through our social worker. And if the social worker recommends a BHET or resources, we're going to try to get him that. His sister is online, so that indicates she quickly got in line when I called her. So that indicates he does have family support. Unfortunately, his mother died in the last few years, and he does have family that cares about him nonetheless. We'd ask the court to give him as low a bond as possible, but we will be seeking help for him.
All right, a $1,000 surety bond, stay away from the Circle K or the BHET. And no drugs, alcohol, weapons, or guns while on bond.
How much was that?
1,000 surety.
Next, we go to position 14, Mr. Graham.
This is 24 CR 007-002F. Anthony Graham, charged with 1 count of simple assault, 2nd count of simple battery, pretrial.
With the rest 2024 trespass death by taking. That's open. Got an open shoplifting 22 SC 183991. Open fleeing an officer. Selling marijuana, reckless driving. Possession of a schedule 1 or 2, 24 PI 005-968. He went to felony earlier. I don't know what the bond was. That's all.
Okay.
This is an incident from October the 10th, Your Honor, at 881 Peachtree Street. Police were called. That's the Dollar General. An employee there, who's also the victim, had come to the location for his first day of work and training. His name is Travion Greer, Grier, first name Treivon. While they are on scene, arriving, the defendant was walking on the sidewalk around the same area and exchanged words with Mr. Greer before turning on him in a threatening manner and then picking up a rock and throwing it at this young man, striking him in the shoulder. The victim was able to use his cell phone to call 911, and while he was there on the phone with 911, the defendant kept advancing on him. The victim tried to disarm the defendant with the rock, and right as police arrived, they witnessed the defendant push him. There was also surveillance of this incident that was captured and reviewed by police. We spoke with Mr. Greer, who works at Dollar General. He confirmed the information that I just shared with you and reported having a swollen shoulder from where he was struck with a rock that this gentleman picked up and threw at him. He says he's never encountered this person before, but that the manager there at the location says that the defendant is a frequent visitor who harasses employees and has assaulted someone in the past. He's just requesting no contact. We'd ask for $1,000 surety, Your Honor. Stay away from the location, the Dollar General at 881 Peachtree Street. No drugs, alcohol, or weapons while on bond. He does have a probation violation in 24 SC 000771, as well as the multiple open cases that you just heard about from pretrial.
And you're recommending what again?
$1,000 surety, Your Honor, and stay away. No drugs, alcohol, or weapons.
Okay.
No
Cook from
objection.
McLean.
No, it's mine. No objection to the state's recommendation, Your Honor.
Okay. I'll give it $1,000 surety bond. Stay away from the Dollar General 881 Peachtree. No drugs, alcohol, weapons, or guns while on bond.
Next, we go to position number 4, Mr. Baker.
Twenty-four CR 006996C Shane Baker, charged with 1 count of criminal trespass.
That last one was 500 each.
Oh, yeah, I'm sorry.
6 total, 2024 shoplifting, 2011 battery. 2011 charge out of the Army for assault. That's it.
This is an incident that occurred on the 9th of October at 1590 Mansell Road in Alpharetta. Police were called about a defendant on the location harassing customers. He was reported as standing in the entrance of the location, being rude. And it was noted that he'd received a criminal trespass warning in October, just on the 8th. So within the last 24 hours, police had already returned to the location. The same officer who criminally trespassed him observed him there being rude, and arrested the gentleman. I see he's already got a $3,000 bond. I do show his last arrest was in June of this year, 2024, for shoplifting. We'd ask for $1,000 surety and a stay away, Your Honor. No drugs, alcohol, or weapons.
All right.
No objection, Your Honor.
All right, $1,000 surety, stay away. 1590 Mansell Road. No drugs, alcohol, weapons, or guns while on bond. That's it.
Next, we go to position number 5, Mr. Barnes.
All right. Twenty-four CR 0070088, Jaquavius Barnes, 2 counts of battery family violence, pretrial.
Eighth arrest. Last arrest was on the 4th of this month. Terrorist threats, trespass out of Clayton County. 2023 battery DV hindering. 2019 ag assault battery DV cruelty in the first offender, and he got 2 bench warrants.
Okay. State.
Your Honor, this is an incident that occurred back in May of 2024. There's been a warrant outstanding for a period of time. Police were called to 245 Basswood Court. This is a South Fulton case. There, they spoke to the victim, who is Michelle Todd. She is listed as the ex-wife of this young man. She reported that the defendant punched her in the face. She was seen to have a swollen and bloody bottom lip, as well as a swelling knot on the right side of her forehead. This defendant has a prior battery conviction out of Fulton County that he received a first offender disposition on. That's the only reason why today we don't have a felony in front of you. That was a 19 SC case with the victim, Shanquita Barnes. He also has a failure to appear for 24 CR 002-060H against the same victim, Your Honor, Mrs. Michelle Todd, and 23 CR 00513-0H against the same victim, Ms. Todd. We spoke to Ms. Todd today. She says that she and the defendant have not been married, but they live together at the incident location and share no children. She confirmed the events in the warrant and reported that he'd just been arrested last week, which is the terroristic threats out of Clayton County you just heard about from pretrial. She reported that Mr. Barnes has a drug and alcohol problem, and she'd like for him to get some help. He gets violent when he's under the influence. She did acknowledge that excuse me, hold on. She did acknowledge that they had 2 open cases and that they're required to have no contact with each other. I'm guessing that that is Ms. Todd, who's on the phone or on the Zoom. I would note that there were jail calls being made today. The defendant calls the victim, telling her he doesn't have a bond and what he's charged with. And he tells her, I need to be out by tomorrow. Why does everybody know I'm in jail? And she says, could you keep calling everybody? He calls her again and asks her if she's going to get him out. They argue, kind of nonchalant. this is a risk, Your Honor, for not just anybody who's around these individuals, but for the public in general. This is also a lethality issue. The defendant in front of you, if you put him on a bond that allows him to get out and have contact with this woman, it'll be now the third bond that he's on for an open case with this young lady, Mrs. Todd, and multiple orders already exist requiring him have no contact with her. He's got prior violent conviction against a different victim, and she told us, reported, not that this didn't happen, but that there's a drug problem and he needs help, and that he was just arrested for a violent incident last week. So although the victim may be saying that she wants contact and she wants him home, the state's position is that she's not in the best position to make a judgment about her safety, just given the facts that have been presented here. So we'd ask for a $5,000 cash bond, absolutely no contact with the victim in this case, Michelle Todd. Stay away from the location, that's 245 Bathwood Court. No drugs, alcohol, or weapons while on bond. And he currently has a $7,500 surety bond on that 24 CR case and a $2,500 surety bond on the 23 CR case, which again are both cases victims, same victim, Todd, Mrs. Todd.
All right, is the victim on the line, Ms. Todd? I don't see an iPhone anymore.
Yes, I'm here.
If you're going to speak, I must see your face. You've got to turn on your camera and be sworn in.
Okay, my camera is on.
Come, Judge.
Where are you? Oh,
Right
I
here.
see. Oh, iPhone. Okay. I was trying to track iPhone. All right. Do you wish to address the court today?
Yes, I do.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Put your hand down for me. Are you in fear of Mr. Barnes?
No.
You want to have any further contact with Mr. Barnes?
I do. We've been together 3 years. We live together. The only thing is he's not a bad person and he's not a violent person. He only just violent when he's under the influence or alcohol. So I'm the type that will try to help a person. And jail is not going to help a person being behind bars trying to get help. So if you can just get him into a drug rehab and alcohol rehab, then I'm fine with that. But I'm not afraid of him.
Okay. Any cross-examination?
None from the defense, Your Honor.
State.
Just briefly, Your Honor. The 23 CR case, Ms. Todd, the first case of these 3 cases, excuse me. You aware that the defendant failed to appear in court in June and that there's a warrant or he's got a rule nisi? His bond is being surrendered. You aware of that?
No.
Okay. This was an incident in August of 2023, a battery, family violence, and obstructing a 911 call. Do you remember that incident?
Yeah, I do remember that, but I don't remember the first with him being in going to court and us going back and forth to court. Basically, my mom just passed. So he really been a big help to me, and he been there with me through the journey with my mom. It just been fresh with my mom being deceased for 2 months. So he was kind of helping me taking care of her.
Okay, and that's why you've been in contact in violation of his court orders and he's not going to court?
Oh, no, I am not the reason that he's not going to court.
Okay, so what were you explaining to me? I was asking you about whether you remembered the incident in 2023.
Okay, which case in 2023?
So the one I was just asking you about is August 2023, August the 21st.
I remember that incident. So you'll have to refresh my memory. I don't remember that.
Have you been under subpoena or been in contact with our office on either of the 2 cases that are open?
No.
Okay. And you're aware that you have bond orders that require him to have no contact with you, correct?
No, nobody never told me that he didn't supposed to have no contact. It was just no violent contact. Nobody
Okay.
told me that he don't supposed to have no contact with me.
Okay. And did you call the police when this incident happened in May?
I did.
And you had a busted lip?
I did.
How many children do you have?
I have 2.
And are either of them the defendant's children?
No.
Okay. And how old are they?
My son is 24 and my daughter is 17. Neither one of them was home.
And do they live with you?
My 17-year-old, she does.
Got it. And what kind of substances are we talking about here for Mr. Barnes?
Like just, I guess, like send him to a
No,
class.
I'm asking you what kind of substances he uses.
Oh, like alcohol, and he pop perks, he pop pills.
Where does he get those pills?
I don't know where he get them from.
Does
But
he
I'm just afraid that he's gonna buy from somebody and he might end up dying from them, since it's so many people dying from pills. So
Yeah.
I'd rather get him help. I'm
Got
seeking
it.
for him some help.
Does he work right now?
He does.
What does he do for his job?
He's at DHL. Then his second job was with Amazon.
Does he drive?
No.
Okay, well, that's good, I guess. And is it your position today in front of this court that you don't have any intention of separating from this gentleman?
No, we're not going to separate. I want to get him help.
Okay, so now you know that there are court orders that require he have no contact with you that are in 2 different cases. You're not concerned about the law and orders of the court and your safety?
I'm not afraid of him.
Okay, you like getting your lip busted and having the Clayton County Police come a week ago.
Well, he didn't bust my lip in Clayton County. So, I mean.
No, that was just, you told us when we spoke to you earlier, after this incident happened in May, where you had a busted lip, you said that he was just arrested by Clayton County a week ago, correct?
I did. I stated when
Right.
you me, how did he get picked up on these warrants? I said he was arrested in Clayton County for throwing a cell phone. I never stated to you while I was asleep that he busted my lip.
No, I'm talking about when he busted your lip in May. That's what we're talking about today. That's what he's in jail for.
Yeah.
So it's your position that this kind of behavior will continue until he gets some help? And that's okay with you?
Well, I guess, but
Okay.
that's not gonna continue on to happen.
But it happened last week.
He didn't touch me last week. He just threw the phone. It didn't.
Oh,
The
okay.
phone didn't- He threw the phone. So when you asked me,
Okay.
and you
Got it.
called, I stated to you that he threw a phone. I never told you that he hit me last week.
Okay.
He only get violent when he's drinking. Other than that, Mr. Barr is not a bad guy.
Got it. I appreciate you sharing with us today. The 23 case, Your Honor, is a battery, family violence, and hindering a 911 call. It includes children being present. Or no, I think it just mentions the fact that she's got children. It says no further contact whatsoever and to stay away from this location. And that's your bond, signed August the 22nd of 2023. The bond after that got higher, the $7,500 surety bond for 24 CR 007-008H. Also requires no contact. I can't pull it up right now. Let me see if I can find it a different way. We'd be asking again for a $5,000 cash bond. While I can relate to the tone and attitude of this young woman, I understand she says she's not afraid of him, and I absolutely believe that. But what she's just explained to you is that she's going to allow herself and anyone around her to be the victim of violence because she believes this gentleman needs help, and it's worth dealing with this kind of behavior. That's an issue for the court. It should be an issue for the court. It's an issue for the state. It's a lethality issue. We'll renew our request for a $5,000 cash bond.
All right. PD
And we'd
Cook?
ask that the court explain to Michelle Todd, that she would now be in violation of court's orders.
You are, Ms. Todd. And you're causing the defendant to be in violation of him as well. And so you've been informed, and I'm sure you are aware, but that'll be your decision, but it's not going to bode good for the defendant. Let's see what his attorney has to say. Mr. Cook?
Your Honor, my client's 34 years old. He has been working at DHL for a few months. A person of very modest income. So that is the recommendation would be a very high bond. Would in effect be a very high bond. Beyond that, we're going to leave this in the court's discretion.
Okay. All right, based on what I've heard, and I don't know what it's going to take to get, Mr. Barnes to straighten up and stop. The biggest thing is when I give an order, and the other judges are the same way, we don't like for them to be violated, whether it's in this county or any other county. So I'm going to order the $5,000 cash bond. Maybe that'll get Mr. Barnes's attention. And with that cash bond, going to order a stay away from the Bathwood Court, which I assume is Miss Barnes's address. Or if he makes bond, he needs to find somewhere else to go live while he's on bond. I'm going to order no further contact with Michelle Todd so we can, I don't know, I say cooling off, but it looks like that doesn't happen. So he needs to find somewhere else to live, go get him some help. I can't make people go to counseling or make people go to AA and things of that nature. I could order him to do it if she wants me to. I don't know if it'll help.
We'd ask for a substance abuse evaluation.
Yeah, I don't know. Can he afford it? He's not working. Well, he was working at DHL. I usually don't order ADET at this level and just have him to go to some AA courses twice a week. See if he can start on that.
Well, forced sober time shouldn't hurt.
Huh?
Forced sober time wouldn't hurt the situation.
Yeah. But I obviously know and sounds like he needs help. So I'll order him to go to AA classes 2 times a week for now. And stay away from Miss Todd. Let's take a break so we don't keep getting cases all over the state, different counties. And $5,000 cash, no drugs, alcohol, weapons, or guns while on bond. That's it.
Thank you.
2,500 per charge, Judge Mason?
Yeah, we'll split them 2,500 each.
Next, we can go to position number 6, Mr. Brand.
This is 24 CR 006992E, Omar Brand. Is this our last case?
No, Your Honor.
Because I've seen the first
Damn, we
charge.
got
I don't know what the facts are.
Yes, Your Honor, this is going to take an empty courtroom or break out, I think.
All right. Because of his first SB charge, just wait till we've got a clear courtroom.
Okay, we can go to position number 20. Have you seen the second row? Position 20, Mr. Jones.
Okay. This is 24 CR 006988A, Oscar Jones. Charged at 1 count of willful obstruction of a law enforcement officer, 2nd count criminal trespass, 3rd count loitering and prowling.
33. He got a probation hold and a bench warrant. So he got an open burglary, 1st degree, possession of tools, theft by taking 2 counts of trespass, 1 count of obstruction. It's 23 SC 188247. 2019 burglary, 1st degree conviction. 2018 burglary, 2nd degree possession of tools conviction. 2015 terrorist threats conviction. 2014 burglary obstruction conviction. You get the picture.
Mm-hmm.
Your Honor, this is an incident from last year, October 2023, from 395 North Yards Boulevard. This was a fenced-in construction site at that location. Police were called, Georgia Tech Police specifically at about 2:30 a.m. There was a burglar alarm that went off at the location. It's a construction site. Again, it's managed by a company and individuals. And while investigating, the defendant was stopped there on the location. He fled, was seen trying to squeeze through the fence and get away. Officer Bohr directed him to stop. He ignored those commands and continued to flee, and a taser was deployed. He was identified and seen to have active warrants. We'd ask for $1,000 surety and stay away from Georgia Tech. No drugs, alcohol, or weapons.
All right.
Your Honor, unless Mr. Jones disagrees with me, I think that's within the range of reasonableness there. The other man.
State's recommendation, the 3,000 surety.
I thought.
I said 1,000 on each.
Oh,
yeah,
which would be a total of 3, right? Yeah, 3,000 surety. Is that what you don't have any objection to, Mr. McLean?
I'm sorry, I was not doing the math. I would ask the court to consider something in the range of 1,000 or 2,000. We realize it's not going to be a signature bond situation. I would point out, of course, I mean, as has been pointed out already, it is a year ago.
And I'm assuming he's not a student at Georgia Tech, correct?
Correct.
How old is he?
He is 51 years old, Your Honor.
All right, I will give him a $2,000 surety bond, 1,000 on the obstruction, 500 on the trespass, and 500 on the prowling. So that's a total of 2,000 surety. Stay away from all Georgia Tech, which is a great deal of downtown Atlanta. So don't go on any Georgia Tech property, Mr. Jones, else you'll be arrested again. And no drugs, alcohol, weapons, or guns while on bond. That should do it.
Next, we go to position number 10, Mr. Crawford from Jones. Not at the moment. Position 10.
Okay. This is 24 CR 006-999J Dante Crawford, charge it 1 count of battery family violence.
Last arrest was on the 8th of this month here in county, suspended license. He's wanted out of Gwinnett. State, do you see anything out of state?
You're muted.
I have to look again. I don't think so, but let me look. Your Honor, this is an incident from May of last year. Location is 1103 Chastain Drive at 2:30 in the morning. Police were called there to a domestic disturbance. On scene, the victim, Jasmine Roberts, who's here on the Zoom, reported that the defendant assaulted her and fled before police arrived. She reported that she'd been struck both with closed hands and open hands. She was breaking things off with the defendant, and he became irate. He got on top of her and began punching her. She was seen to have a laceration on her face, and she complained of soreness to her jaw. She had visible bruising on the jaw. She reported that they lived together. She identified the defendant for police, and I believe the police report said she subsequently went to obtain a TPO. We did speak to Ms. Roberts today. She says that she and the defendant are no longer in a relationship and they don't share any children. She did confirm what happened. She said she had cuts and bruises on her face and swelling, and she couldn't eat for a few days because of the jaw pain. She said this is not the first time the defendant had been violent with her, but the first time police were called, and she hasn't seen the defendant since. She no longer lives at that residence, but she is requesting no contact. We'd ask for a $2,000 surety, no contact with Mrs. Roberts. Stay away from her wherever she may live or work, and no drugs, alcohol, or weapons. And I'll pull up the criminal history just to review again. You can go ahead if you want.
Okay. All right. He didn't, who's it? Cook?
This is mine here. Yeah,
Oh,
yeah,
I see. I'm sorry. Hold on, Mr. Cook. Miss
Okay.
Robert. I'm sorry. The victim, is that Jasmine Roberts? Do
Yes.
you wish to address the court, Miss Roberts?
Yes.
Okay, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. And tell me this, are you in fear of Mr. Crawford?
No.
Do you want to have any further contact with Mr. Crawford?
No.
All right. Thank you. All right, you can mute yourself. Go ahead, P.B. Cook.
yes, Charlie. My client is 35 years old. He works he has a couple of jobs. One, he does DoorDash and things of that nature. He also works for his mother. She has her own company, All Around Transportation. I'm just looking at the some information. We have no objection, obviously, to stay away and no further contact. He asked me, he wanted me to put on record that he denies the allegations as stated in the warrant. Beyond that, we'd like to keep the we understand there'll be a surety bond, but we'd like to keep it as low as possible because although he is working these two jobs, his income is very modest. Nothing further.
All right, I'm gonna order the $2,000 surety bond. Stay away from 1103 Chastain Drive. No further contact with Jasmine Roberts. No drugs, alcohol, weapons, or guns while on bond. That's it. Thank you, Ms. Roberts.
What was that bond amount?
2,000 surety.
Have a seat. Second row. Next, we go to position 26. Mr. Watson.
Good, on that last case,
No.
Ms. Roberts doesn't live at that location. Do you want me to put her current resident and work?
Yes, that's fine. This is 24 CR 0070111G. Tremesio Watson, charge of 1 count of battery family violence.
6 total. He got a burglary, theft by taking, trespass, 23 SC 190113. Theft by receiving, obstruction, 24 SC 002828. Theft by receiving, possession of a firearm, obstruction, possession of marijuana, 24 SC 002871. Cobb County case, got a reckless conduct, possession of a firearm by convicted felon, theft by receiving. Ag assault, possession of a firearm during the commission of a felony. Ag assault, possession of a firearm during the commission, battery, 24 PI 005639.
So, Your Honor, this young man was just released from the Fulton County Jail on September the 5th, 2024. He's in front of you on an incident from September the 11th, 2024, 6 days after his release. He was released from the Fulton County Jail on 24 PI 005639. That is a Superior Court case where he struck his brother with a hammer and shot his sister. He's got open burglary as well in Superior Court. Police were called on the 11th of September to 777 Eloise Court, Apartment A. There, the victim, her name is Anaya Weiss, spelled Anaiaha, and Weiss. It's reported that between 3 and 8 a.m., there was a dispute. Police were called to the location, and when they arrived, Ms. Weiss was outside in her mother's car. She reported that the defendant is her boyfriend and that they'd engaged in a dispute. He attacked her at about 3:30 in the morning after he went through her phone. She ran to a neighbor's house, but nobody answered the door. So reluctantly, she returned back to their apartment A to try to get her phone, because of course the defendant had it because he was going through it. And he grabbed her and slammed her to the ground. Her head struck the ground, and he took her head and repeatedly hit the ground, using her head to hit the ground multiple times. She was able to flee. She grabbed her keys. The defendant actually followed her, but had left when police got there. She was seen to have a visible knot on the right side of her temple. We did speak to Mrs. Weiss today. She says that she and the defendant are in a relationship and share a child. She confirmed the information in the warrant and claims this has never happened before, and that she got her phone back the next day, but they've been in contact since this happened and there's been no violence since. She let us know she doesn't want to press charges and she's not in fear of the defendant and she wants to continue contact. And I have to say, I'm not surprised she said that, because that's exactly what he told her to say when he called her from the jail and they discussed it. He asks her, can you be on Zoom in case they say something wrong, and then you can tell them what I told you to say in pretrial. Just come tomorrow and tell them everything was a lie. He sure hopes he gets a signature bond. They talk about how they're going to look for a house together. He talks about the conditions at the jail. He sure is glad this case isn't a felony. So what you are hearing is evidence of a continuing crime. That is tampering with witnesses. That is even arguably forfeiture by wrongdoing, by asking someone to make themselves available and to change their story, suborning perjury. Evidently, this young man whose date of birth is 2005, and he's out on bond after he hit his brother in the head with a hammer and bit him and shot his sister, doesn't understand that there might be rules he's got to follow. So although the victim, Mrs. Weiss, has reported to our office and victim advocates today that she's not in fear and she wants him to come home, it's very clear based on the recorded phone calls that that's exactly what he told her to say, and that this young lady's in danger, just like she was when she called the police on the 11th of September, 6 days after this young man was released from jail. He's got one count in front of you, and we'd ask for a $3,000 cash bond, Your Honor. No contact with Mrs. Weiss. That means calling her from jail, stay away from her residence, no drugs, alcohol, or weapons while on probation. Sometimes people need to be able to have some time away, even if it's just not receiving phone calls. I think it's hard for us to realize that just asking people to stay away is such a huge issue. A victim who can literally never go without receiving constant phone calls is never getting a break.
Okay. McLean or Cook? Whose case?
I'm sorry,
Cook?
I'm on mute.
Oh.
Sorry, I was muted. Your Honor, my client is 19 years old. He works at UPS. He loads trucks. He has packages on the Beltline. Before that, he worked at Amazon, so he is industrious. Your Honor, his youth and his industrious are two arguments in his favor. Would like to ask the court to consider as low bond as possible.
And Your Honor, if you want to sound from Ms. Weiss, she's here. What I did leave out is that during the jail phone call, their very first one, they discuss how the state picks up charges even if you don't want to move forward. And she tells him, I just won't come to court moving forward. And then they'll have to drop it.
All right, Ms. Weiss, would you like to speak? Or address the court today?
Yes.
Turn on your camera. All right, you're not driving, correct?
No, ma'am.
All right, can you sit up a little bit for me? We're in court. All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yeah.
All right, put your hand down for me. Are you in fear of Mr. Watson?
No.
Do you want to have any further contact with Mr. Watson?
Yes.
Okay, you all don't have children together, is that correct?
We have a
Oh,
1-year-old.
you do have one. Okay, how old is your child?
1.
Okay. So you have a 1-year-old, okay.
Yes.
All right, we've got to understand, stop picking up cases. But, all right, I don't have any other questions. Anyone else?
Just briefly, how old are you, Miss Vice?
I'm 19.
You guys are 19 and you have a 1-year-old.
Yes.
Okay. And who do you live with?
My mom.
And when, is that the address where this incident occurred? You were sitting
No.
in your car at 777 Eloise Court?
That's not the address.
Okay, what's the address?
314 Cog Hill Drive, Fairburn,
Got it.
Georgia.
So that's not where this incident took place?
No,
Okay. What was 777 Eloise?
his sister's house.
Okay. And so you're living with your mom at a different location now with your child?
Yes. Yes.
Okay. And is it safe there?
Yes.
Does your mom allow this young man to come over?
Yes.
And does she know that there are these violent incidences?
Mine, personally?
Yeah, does your mom know about this incident and the
Oh,
violence that
yes.
occurs?
Yes.
Okay, and is she happy about it?
No,
How old is, you have a 1-year-old? Is it a boy or a girl?
a boy.
Okay. And is he around when this kind of behavior happens?
No.
Where is he?
When this incident happened,
Mm-hmm.
he was with my mom.
And do you work?
Yes.
Where do you work?
I'm a caregiver at the Charter Senior Living.
And who takes care of the little one while you're working?
My mom.
And does Mr. Watson work?
Yes.
Where does he work? He's loading trucks?
UPS.
Yep. And how does he get to work every day?
He drives.
And he stays with you?
Yes.
And does he contribute to your mom's home?
Yes.
How much does he pay?
1,000.
When?
The first of the month.
And so he was out of jail for 6 whole days before this assault happened, correct?
Mm-hmm.
Did he come right back and you guys were together right after September the 11th? How long did it
Yes.
take?
Oh, no, not right after. No, it took about a week or 2.
Okay. And at that time, were you living with your mom?
Yes.
And so when did he show up and start staying at your mom's house?
Like I said, a week or 2 afterwards.
Okay.
After the incident.
And has anything violent happened since?
No.
Okay. Those are all the questions I have, Your Honor.
All right, we will move along. PD, which one? McLean or Cook?
It is mine, Your Honor. I had mentioned that he did work at UPS, the loading of the trucks, the picking of the packages off of the belt line, putting them on the belt line. It's a conveyor belt. And before that, he worked at Amazon for 6 months. And he is but 19, so this is the beginning of his working as an adult.
All right, I'm gonna order. I just don't like what I'm hearing here. And I'm gonna order the $3,000 cash bond. And with that $3,000 cash bond, I am going to order him to have no further contact with the victim, Anaya Vice. No further contact with Miss Vice. He needs to stay away. Need I say they need cooling down even from a month ago. And if there's going to be any visitation, which it probably should not be, then it'll have to be precipitated by a third party because she can't be around him. He can't be around her. And to not go by her house or job, stay 200 football fields away from her. That's what the order is going to say.
200 yards.
200 yards.
You said
Sorry,
football fields. That's a long way.
200 football fields. That might be right, but two football fields. Also, no drugs, alcohol, weapons, or guns while on bond. And that's the order of the court.
Ms. Howard, can you message me that stairway address? It
Oh,
was different
that
than what was on the,
314 Cog Hill Drive, was that it?
oh, what was it again?
Was it 314 Cog Hill Drive, ASG Allen? Sometimes I get them
It
right.
was 314, but I wasn't sure of the name of the street.
I thought she said Cog Hill Drive.
Let me look.
Oh.
Oh.
You not shooting. This is position number 6. Mr. Brand.
All right, this is 24 CR 0069992E. Omar Brand, charge of 1 count. Are we stopping the stream?